magazine. So we have some excellent representation here. And Bruce, I guess I'd like to kick things off with you. You have a few things to say.
Okay, thank you very much, Lisa. I appreciate that. And so I was asked to talk a little bit about the perspective of multiple offers in the Code of Ethics. And there are several parts of the code, but 2 or 3 primarily that are directed to multiple offers. Yeah.
Bruce, can you hold on for a second? We have I think an NP Dodge office that might need to mute.
You want to try to mute all?
Christy, can you do that? Can you mute everybody for now, but the facilitator?
How's that?
Sure, let me try. Oh, Bruce, did you do it? Thank you.
Yeah, I did it. Okay. All right. Lisa gives me a thumbs up. That's good. So there are several parts of the Code of Ethics that apply, and there's lots of questions that come up about multiple offers that may or may not be in the code, a lot of misunderstandings, as well as some areas of the code that don't cover things like this issue of buyer love letters. It's covered generally, but there's no specific standards of practice. So let me just very quickly run through some of the basics, and I'm going to share my screen here. Before I do that, let me post in the chat box a copy of the PowerPoint presentation in a PDF format that you're going to see parts of here today. And this is for your reference. You can feel free to download this and use it as your reference point. So just give me 1 second here. And you should see that now in your chat box. It's called Code and Multiple Offers. Feel free to download that whenever you like, and if you care to. And then we'll take a look at some of the issues within the code, just real quickly and briefly, to kind of give us a baseline of where we are in how the code talks about handling this whole concept of multiple offers. First thing I always like to talk about is just the basics. And the basics, of course, we know are Standard of Practice 1-6, as well as the license law. Talks about the fact that you have to submit all offers to the seller. The code specifically says submitting all offers and counteroffers objectively and as quickly as possible. So sometimes in multiple offer situations, that can come into this whole area of, well, gee whiz, we're going to look at all offers at a certain time. You've got to make sure that that's been that marketing strategy has been approved by the seller, and you've got the seller's agreement to go ahead in that way. One of the key standards in the whole area of multiple offers is Standard of Practice 1-15. And Standard of Practice 1-15 is important, A, for what it says, and also B, for what it doesn't say. So let's just walk through that. It talks about the first part talks about realtors in response to inquiries from buyers or cooperating brokers with the seller's approval shall disclose the existence of offers on the property. So let's take a look at that. It's really 2 or 3 pieces. First of all, cooperating brokers are required to ask if there are other offers before the listing broker has any obligation to say anything. Secondly, the seller has to have given approval for the fact that there are other offers to be disclosed. Assuming that you are asked and the seller has given approval, then the listing broker is required to disclose the existence of those offers. The other part of Standard of Practice 1-15 goes along with that and says, okay, where disclosure is authorized, if you're asked, you also have to disclose the source, if you will, of the offers, whether they were obtained by the listing licensee, somebody in the listing licensee's firm, or by a cooperating broker. So there are several pieces to make sure that you comply with these areas. So if we break this down, if you're asked and if the permission is given by the seller, then you have to disclose, as I said, the source of the other offers. I'm going to stop right there for just a second and just mention that this process then kind of goes a little differently than some people think multiple offers and what the listing broker is required to do. For example, there has been a kind of a misconception in the marketplace that once there are multiple offers, the listing broker is required to tell anybody who submits an additional offer that there are multiple offers. And clearly the standard of practice doesn't say that. It says that the cooperating broker has to ask, do you have any other offers? And I'm sure almost everybody is doing this now, but if you're not, you really need to. Are there other offers on the table? And in fact, when other offers come in, if you're the first one and other offers come in, the listing broker is not required to call you back and tell you that there are other offers. So it's not uncommon and would be a good idea to just touch base with the listing broker if you expect that multiple offers and you happen to be the first one and they say, no, there's not been any multiple offers. Call them back in whatever prior to the time they're going to be presenting the offers and say, do you have multiple offers now? Allowing the buyer to change their offer however they may choose to. So that's one of the pieces that you should always be doing. And then the second piece is, once they tell you, yes, there are multiple offers, ask the source. So what's the source of your offers? They don't have to give you the terms. They don't have to give you the names, but they can say, they have to tell you whether it's from them personally. The other offers are from them personally, from somebody in their firm, or from cooperating brokers, if you ask them that. Then the last piece of what I'd like to just touch on initially here is the idea of this idea of confidentiality of multiple offers. This is in standard practice 1-13 sub 5. And actually, let me go back for just 1 second to the previous slide. There's one other nuance here for cooperating brokers, and that is that if you question whether or not your offer has been presented, you can ask the listing broker to submit to you a written affirmation that the offer has been presented, or that the seller has refused to have the offer presented to them. You have to give a written request to do that, and that's new as of 2019 in standard of practice 1-7. So upon your written request, the listing broker shall provide a written affirmation to the cooperating broker that the offer has either been submitted or that the seller has waived presentation, refused to see the offer. So then that last piece that I wanted to mention is standard of practice 1-13 subparagraph 5. And that's this idea that, somehow the existence or terms of an offer are confidential. And basically what standard of practice 1-13 says is that we have a list of things that we're required to disclose when we enter into buyer-tenant agreements. One of them is the possibility that sellers or sellers' agents may not treat the existence, terms, or conditions of offers as confidential unless required by law or by regulation. So in other words, the seller has no duty of confidentiality about the offer to the buyer. So that gives you a brief overview of kind of what the code talks about in terms of how multiple offers get handled. So Lisa, that's kind of the start to what I wanted to talk about, and ready to kick it back to you.
Okay, terrific. Thank you so much, Bruce. I can't see everybody on the stream. Christy, did Greg Lemon end up joining us? No? Okay. I can't hear you.
I'm sorry. Yes, he's on,
Yes,
Lisa.
I'm here.
Sorry.
Okay, great. Hi, Greg. How are you?
Oh, Lisa, very good. Sorry, I was a minute late.
No problem. It's okay. So Greg Lemon is the esteemed director of our Nebraska Real Estate Commission and deals with a lot of repercussions, I'm sure, of multiple offers. And so the first question I have for Greg, and then I'll move on to Troy, is what do you see the most calls about from consumers in terms of their perception of the problems with multiple offers?
That's a really good question. The call we get the most often is, in this market is somebody saying that they don't think their offer was presented, that they made an offer that was over, cash offer over market price, and they can't believe that that the offer was presented because they didn't get the property.
That makes a lot of sense.
And, as mentioned by Mr. Aydt, the Code of Ethics has the provisions about asking for proof. We don't have anything, we have a law that requires all offers to be presented, but we don't really have specific provisions saying you have to show that. Now, as a matter of course, it gets into the question of what is presenting an offer too. And I think, I'm not out there doing what you guys do, but I'm assuming there's times when you start presenting an offer and somebody asks, well, what's the price? And they say, well, it's this. And they say, well, I don't want to hear anymore. And we control what the agents do. We don't control what the sellers do. But at that point, I think it behooves the agents for your own protection to always make a record that you made an effort to, that you, on this date, you presented this offer or attempted to present this offer and the seller declined because of the reasons we've talked about. And those calls with the people, I generally will tell them, I talk to them about the market, and I will say that unless you have proof, that's going to be a hard one to pursue as a complaint, but that is the call we get the most often.
Gotcha. And I think an easy way to protect yourself against having to go through the hearing process is to email it on if your seller has email at the first available opportunity, because then that can be undisputed. So it's always good if they do have email. And something that we talked about at our last commission meeting informally a bit was that if you're holding all offers until a certain time, it behooves you to have it in writing from that seller that they don't want to receive any offers until that time. Otherwise, you could potentially have issues with not presenting in a timely manner. Do you agree with that, Greg?
Yes, I do. Absolutely. And I think, going beyond that, even if the, offers are, everybody's kind of trying to make the rules on offers. The sellers may be saying, we want to hear everything. We want to hear everything on Saturday afternoon too. The buyer may say, I have an offer that's, I'm going to make an offer. It's going to expire Friday afternoon at 1, the day before.
Right.
And if even if the buyer knows that the seller has said, I don't want to hear any offers till Saturday, if they make an offer that they say expires before that time, then I think just reading the law as it's written, presenting all offers in a timely manner, the agent has an obligation to contact the seller and say, you have an offer that's going to expire before that time.
Yes, that is a great point, Greg. Thank you so much for sharing that. I appreciate that. Troy, I'll ask the same question of you. What issues are you hearing from consumers? And you're probably hearing about other agents. And what's your advice on, how people can avoid getting caught up into trouble?
Sure. So similarly to Greg, I'm getting a lot of phone calls about the presentation of multiple offer situations, and some very creative tactics. I tip my hat to some of those in this group with the creativity that has been conjured up over the last several months. It's pretty impressive, honestly. When it comes to the calls that I'm receiving, the questions certainly along the lines of what Greg talked about have come up, as well as if there's an offer that expires prior to the time the sellers would like to have offers presented that has an escalation clause, do the sellers have the ability to utilize that escalation clause at the time that they're sitting down to review offers. And along those lines, that answer is no, because at the time the sellers are reviewing those offers, that first offer received expired. And so that escalation clause and that previous offer have expired and are no longer on the table to be considered. And I agree with everything that Greg said. If the sellers are limiting the time period for when offers are going to be reviewed, be sure you have that in writing. The more that you have in writing to back up and to show as evidence in case a complaint is filed, the easier it's going to be in order to defend you for any complaints that are received. Another one that along the lines of offer presentation that I have run into recently are buyer's agents making requests to present the offer directly to the sellers themselves. And so my advice on that has been to leave that to the sellers if they're open to it, but their agent must be present at the time. And Greg, you can correct me if I'm wrong with any of that, but what I'm trying to avoid is buyers agents directly making presentations of offers to selling parties.
Yeah, I mean, that's a direct violation of the provisions of the law that say if the seller's represented, the buyer's agent is supposed to go to the seller's agent. So I agree, you would not want to do that.
Yeah, and I would also comment, though, that there is a right in most MLS rules, and it's in the model NAR MLS rules, that says the cooperating broker has a right to appear to present their offer, of course, with the listing broker and the seller present, unless the seller has indicated otherwise in writing. So cooperating brokers do have a role, and they definitely can be out there to present their buyer's best interest. But it obviously would be, as both Greg and Troy have said, in the presence of the listing broker and through the listing broker with the seller present.
Those are great points. Those are great points. Thank you. And I liked that ethics are the comment that you made about the escalation clauses. I think escalation clauses are some of the most confusing things that we have going on in today's offer situations. Bruce, what advice do you have about escalation clauses?
Well, I will tell you, quite frankly, I think they're a bad idea. Now, the fact that I think they're a bad idea doesn't mean they still get used.
Right.
And so when people have asked me when I was general counsel for companies, they'd say, can't we just have this quick little clause? And I would say, no, I'm sorry. By the time I get done with it, to put all the proper assurances in there for a fair and balanced form, it's going to be about a page long and got about 16 paragraphs to it. And I'm exaggerating a little bit, but there's a lot of things in an escalation provision that parties would have to have in it. And it's not something an agent can just pen out real quickly. It's got to be prepared by a lawyer, and you should make sure you've got provisions in it to protect the buyer in terms of what other bona fide offers are there. Right. Can I see those bona fide offers? Is there a cap on how high I'll go? And so that I just see lots of problems with escalation clauses, even though I know they're being used quite frequently today.
I would agree with that wholeheartedly. As a person who does a lot of listing business, I would prefer not to see escalation clauses, but of course it's not my choice. It's always the seller's. My advice to the people in my brokerage consistently is to counter with clarification on all of the major points versus accepting as written, because otherwise you can end up with a dogfight on your hands. Greg, Troy, Bruce, do you have any comments on that advice, whether it's good or bad?
Yeah, I mean, I would say, yes, that's good advice. I know listing brokers here in our area. They are simply saying, put your best foot forward. This is a strategy they've discussed with the sellers, and of course have seller
Right.
permission. Put your best foot forward, buyers. No escalation clauses. We prefer not to have an escalation clause,
Mhm.
and you can't stop somebody from doing it,
Right.
but you've counseled the seller in advance already about the issues that might occur.
And
Yes.
I would agree with that, and counsel the same thing. One, as we have said consistently, if you're going to use them, have an attorney draft them. We don't necessarily recommend using them. One of the problems I see is when you get in a situation where there's multiple escalation clauses,
Right.
where are you at then, and how do you figure that out? And I've heard that there are even people writing escalation clauses with no cap in them. And so when you have two escalation clauses with no cap, where are you at?
Right.
Yeah. Oof. That's rough.
There's a few things in the chat, Lisa. I don't know if you,
Oh, I'm sorry.
no, that's okay. There's, just gonna throw that out there.
Okay. Well, I'll let Troy go and then I'll try to address some things from the chat. Is that okay?
Yeah. To add to what both Bruce and Greg have said, another issue that I've run into with multiple escalation clause situations, two issues I'd like to point out. I have had questions where sellers agents have asked if they are then able to go back to each of the buyers that have submitted escalation clauses in order to perhaps counter that and further increase what's been escalated. And they're trying to establish a bidding war in the sense that it almost turns it into an auction. And I would be very cautious of that, because that is not the legal way to go about handling any kind of an auction, and you don't want to get in trouble with being accused of that. One of the other issues that I've seen, when we have these escalation clauses, they escalate at different rates from different prices, and the math sometimes gets confusing and tricky. And so it needs to be confirmed and verified that you're landing on the proper final price
Right.
that's going to be in the purchase agreement.
Right. I would agree. And that's why I advise the counter so that it becomes a part of the purchase agreement and you have something more solid than just a text or a verbal. Okay. Some questions. Has anyone dealt with an open-ended escalation clause? Has anyone here on the call dealt with one, and how did that turn out? Okay, no one on the call has officially dealt with that, but that's, yeah.
Lisa,
Yeah.
I had one of my listings, and my sellers said that they wouldn't even look at it because it was too vague for them.
Yeah.
And they said it just didn't feel comfortable to them, so they ruled it out immediately. My sellers just didn't even want to look at it.
Yeah. Yeah, I understand. So I have a question here. Could you please touch on a seller's ability to counter an escalation out of the contract? So many buyer's agents believe that the escalation is the final step and cannot be countered, and the seller is required to show all other offers to the buyer. Ryan, yeah, I might need some clarification on that. My position would be that the sellers can counter an escalation. Would you guys agree, Greg, Troy, and Bruce?
Yes.
Yes.
Absolutely agree.
Yeah.
Okay.
Yeah, and that's my point. We've just had situations where we'll be on the list side of things, and we'll just counter out the escalation clause to clean up the offers.
Right.
And we've had agents saying, well, you can't do that. You have to prove to us what the competing offers are. And we try to explain, hey, this is a seller's counter.
Right.
We're not doing the escalation. And it's interesting. We've had a lot of agents that have gotten incredibly upset with that. And it's just trying to explain to them, hey, it's a counter. This is the direction we're going.
So, and I guess I would also say, just remind anybody who argues with that, the fact that a counter offer is a new offer.
Yeah.
And a counter offer kills the original offer. So, I mean, that's just basic contract law, that when somebody makes an offer, they are what the law typically calls the master of their offer. They can put anything in there they want to.
Correct.
It's not as long as it's not illegal, and that includes a counter offer.
Yeah, I think that is an excellent point, Ryan. I agree. I do hear that a lot.
The one thing about, I think part of the question goes to something that's really problematical. We've already touched on it, is, when you get into escalation clauses and multiple offers, people want to see proof that they're in fact, there's another offer in there and they have to go $1,000 high, whether it's an escalation clause or whether it's just it's just a multiple offer situation. People want to see proof, and there's nothing in the law that requires, that's a conversation to have, and it's a good conversation to have with the seller, prior to, but a conversation to have as to whether you want to reveal those types of things. And it looks like it's addressed in the code of ethics as well. But, what I have said to people when they say, well, I don't know, they're telling me there's this other offer, but they don't want to show it to me. And I tell people they don't have an obligation to show it to you, and for better or worse, that's the way it works. And there would be problems whether you do it either way. But, and ultimately, you never want to see it go this far, but, you can see it if you end up filing a lawsuit, do discovery, but that's not really the direction we want to go.
Right. Agreed. Somebody asked, what can we as listing agents put in our listing to discourage this? I don't know. I guess I'll defer that question to our panel.
Well, I will just say that that's another kind of interesting thing I've seen and had conversations recently about, is sellers wanting to say, I only want to sell. It's kind of the opposite of the love letters. I only want to sell to a certain kind of buyer. Or, it's a little different, but it's kind of the same kind of thing, saying, I don't want to see escalation clauses. I don't want to see this. I don't want to see that. And they're a little more, I guess, cocky about that, since it's very much a seller's market. But, one could certainly put in their, in the MLS comments or somewhere that they don't want to entertain escalation clauses, but as stated, the offeror is the master of the offer, and they can still make one. But they're at least under advisement that the seller is disinclined to entertain it.
Right. So talking with your sellers in advance and saying, do you agree with this? Would you prefer to see the highest and best offer versus escalation clauses? And if they agree with it, then that's something maybe that can be stated in MLS comments. But we would, as listing agents, it doesn't relieve us of our obligation to present the material that we are given. Yeah. All right. What are some of the things that frustrate you the most as agents, other than feeling like offers are not being presented in dealing with multiple offers? Any agent like to give a shout out of a question?
I think one of the things that is frustrating for a lot of buyers is just at the time on the market. Something will be advertised as coming soon for 7 days. It goes live on the market Monday afternoon, and at 5 o'clock it's done, and you can't even get your people in to see it.
Right.
And I almost feel that that's doing the sellers a disservice, because they can't, they're not going to see everybody's offer. I don't know where my video just went, but sorry about that.
That's okay. Yeah, that's hard. But one of the things that's happening that I see in the marketplace is so many offers with sight unseen, occurrences going on with no inspections, no appraisal contingencies and everything. We have to present those offers. So that is something that's, I think, occurring a lot. It's actually just shocking. I'd never thought I'd see a market like this. Do you guys agree?
Yes, I've never seen anything like this in my entire career, and that spans back to the 1970s. So I've never seen anything with this tight of inventory, this short of days on market, this level of number of multiple offers. And I've seen several sellers markets where things have been hot, but never with this low of days on market.
Mm-hmm.
So Lisa, I wanted to kind of circle back to part of that comment, and that relates a little bit to this whole idea of the listing broker being, I guess I would say, being straightforward and honest about how offers get presented. And there was a question in the chat box that kind of relates to that. It says, what if the MLS says offers will be gone over on Sunday? A buyer's agent writes Saturday morning with a noon deadline and the seller accepts. So part of that relates to some of the code of ethics that you may or may not be familiar with, and that's standard of practice 3-8. Certainly a seller has the right to control when they accept offers. If they get something presented like that, obviously the listing broker still has an obligation to bring it to the seller, unless there is some other kind of I would say, written arrangement. But we've already talked about, gee whiz, that puts you in a bind if you've got something with an answer time or an expiration time before the time you say you're going to show it.
Right.
You got to get that to the seller. And then let's say the seller, is willing to entertain that or allow the property to be shown. Let's say it's no showings until Sunday, and then all of a sudden they allow a showing on Saturday. Standard of practice 3-8 talks about the fact that a listing broker cannot misrepresent the availability of or access to a listed property. So that may or may not apply to the offer being presented, but if you've also tied that in with like a no show until type of thing, that could clearly apply too.
Can I ask a question about the no-show real quick?
Yeah.
Okay, so we had a deal last week where we had a property. We were scheduled to look at it at like 8:30 in the morning. The first morning it was supposed to go live from a no-show. We got a call at 8:15 in the morning saying that, oh, I'm sorry, we had a showing really early this morning. It's already under contract. There is no way possible that house was shown, had an offer, and accepted within 15 minutes of it actually being able to be shown.
Can I speak to that though? I know what he's talking about, I think, but I think the person who bought that house didn't look at it that morning. She actually knew them and had been there for like a baby shower a year before. So she bought it basically sight unseen.
Gotcha. And there is a fair amount of that happening. One interesting, I'm going to switch gears just a teeny bit because there's so many questions and issues going on. One thing that I'm seeing a problem with is agents not collecting earnest deposit and then their buyers canceling. So in the past, it was very common in our marketplace in Omaha to say buyer will submit earnest within 48 hours. Very, very common, very accepted. I've had it happen several times in my brokerage just over the last month where buyer changes their mind the next morning and has not submitted earnest. So that is something that we as agents have to be aware is a new problem, is buyer's remorse because of emotional bidding, and protect all parties by collecting the earnest now at time of contract. And there are better ways of doing it. We have tools out there like, remote capture of earnest deposit to be able to help us with that. So to make a stronger offer. So I think that it's good for everyone to hear that that is happening in the marketplace now more than ever, and to be aware of that as you're presenting your offers to your sellers. Do they have the earnest deposit in hand right now or not?
Lisa, I thought it's my understanding that on almost every situation, it leans towards buyer's right to get the earnest deposit back. And certainly within that short of a turn time, like a buyer's remorse type thing.
I'll let Troy or Greg speak to that, but there's no time for buyer's remorse in contracts, to my knowledge, on real estate. Would Greg, Troy, Bruce help me out with that?
In certain circumstances, under some contract law, there can be some buyer remorse provisions built in. I think there are for used cars. But for real estate, I don't believe that there is. However, also a blanket statement that says that the buyers would typically get the earnest money back also depends on the language in the purchase agreement, and it may not necessarily be accurate either. And so I do think there's a responsibility to obtain the earnest money and get it deposited properly in a timely manner. And it certainly is a red flag if a buyer is dragging their feet. You know, and when that happens, I would always advise the parties to contact a real estate attorney and discuss what their options are going to be. A lot of times, and especially in the current market, it's probably just worth letting the buyers, well, you know, talk to an attorney so you get advice for each of your specific circumstances.
It's a serious issue though, because if it happens 24, 48 hours later and the other person has bought another house, sometimes it can be a difference of $10,000 or more. So it is a very serious issue on this earnest deposit, not having it in hand. Greg, do you have anything to add to that?
I would, you know, I see apparently it's a practice to say, you know, earnest deposit to be delivered 48 hours or whatever within acceptance. And that just doesn't seem like a very good, I mean, it's not illegal, you can contract or whatever you want, but it doesn't seem like a very good practice to me. And we do get a lot of calls of saying, you know, that was the provision in the contract, but it never showed up. And then everybody's left, you know, as I said, we have authority over agents. We don't have authority over parties, but if you're asking for the earnest, it's a little easier, I think, to say, well, we can't present the offer without the earnest money. Then you got it presented, you got it accepted, and then you're bugging the buyer to get the money. And some people drag their feet or whatever reason. Yeah, and there's not it's interesting because I've talked to friends, you know, who just buy, you know, not buy houses, not flippers, you know, but friends who are experienced buying houses and things like that. And there seems to be a perception that there's a rescission period for real estate contracts, you know, that, oh, you can back out of it, you know, within 14 days or 7 days or whatever. And I'm not sure where that comes from. I think part of it may be that, you know, many times purchasers are subject to inspection. And if the inspections don't go, you know, then it's pretty easy to back out. But yeah, there's this perception. And particularly in this market, you know, people make offers before they really are sure, because if they don't make the offer, they know they're not going to get it. And so, you know, people are backing out more often as well.
Right.
But yeah, there's not in law a, you know, 24, 48, 72 hour decision period in real estate.
Thank you for clarifying that.
And I guess I'd also add, you know, when you're a listing broker, you're counseling with a seller in a multiple offer situation. If you've got two offers pretty close to the same and one has the earnest money with it and the other one doesn't, it's not coming in for 2 days. Well, which is the stronger offer? It's the one who's got the more credibility right then and there, and the one that you'll have less chance of or less difficulty in enforcing down the line. So if I'm a listing broker, I'm going to also make sure that sellers are not only looking at things like price in the multiple offers, but you've also got to look at all the other terms. And one of those terms is earnest money. Is there enough earnest money? And do you have it in front of you? That goes to the credibility of those offers.
Absolutely. And I think it's something that can sometimes get overlooked because we're so used to our traditions. But I think it's something that needs to be scrutinized more in today's tight market.
Lisa, I would like to thank you for bringing that up because this has not been something I've seen yet. And I'm putting 2 listings on this month. So I will absolutely be cautious of it. And I'm a firm believer that the transaction has to be equally as honest and give both customers, the buyer and the seller, a good feeling when they walk away. You shouldn't just be representing the buyer or the seller and saying it's a dog eat dog world, because guess what? Everyone needs to be happy. And I'm a firm believer in that. So I appreciate what you just told me. And I will definitely make sure we're getting some earnest deposits.
Yeah. And I mean, I believe in fiduciary duty, of course. I'm passionate about that. But what I've found is when you don't work towards mutually rewarding solutions on things where there's that possibility, then the transaction goes sideways somewhere else. If you are trying to make people lose, so to speak. So it's best to try to create as mutually rewarding of a situation as you can so that another problem doesn't magically pop up to make the transaction go bad. Somebody has asked me to touch on love letters, hearing that there's potential for unintentional fair housing violation. I've been hearing that too. Absolutely. Yeah. Oh, that's sad. Those were fun to read. But here we are. So Troy, Greg, Bruce, anything, comments?
Yeah, I think that my last article in the Realtor newsletter was about love letters and double checking the ethics of them. And the National Association has put out clarification on love letters as well as to how they're discouraged across the board and what kind of fair housing violations you can run into. But it's things that can be completely unintentional. You know, where a family writes in there and says, this house is perfect, we would love it. I can just picture our kids running down the stairs on Christmas morning and having all the presents under the tree. And right then and there, you've already given information that would commit several fair housing violations. And so, although they're well-intentioned, the dangers of utilizing them in order to accept an offer is dangerous.
Yeah.
And I would certainly agree with that. And I think NAR's advice in their legal area has been very sound on this. And while they have been very prevalent in the past, there has been some litigation. There's some litigation in Massachusetts right now. Little different fact scenario than what you would probably deal with or I would deal with in my market. But bottom line is that when the seller learned the name of the buyer, they hadn't learned the name of the buyer until they were presented with the offer. When they learned the name of the buyer, they refused to sell to them because they had a name that sounded like they were black. And so part of the danger of love letters, as Troy said, is getting into this idea of a description of the family or the buyer that could unintentionally also then sway them against other buyers in a multiple offer situation. And those other buyers could be members of a protected class, even if you do know their name. So in general, not only are love letters now very much discouraged, recently I've seen a trend in our marketplace where listing brokers discuss it with sellers, say, hey, there's some fair housing liability here for everybody. And, you know, if you give me an instruction, it might be a good idea if you give me an instruction not to accept buyer love letters and to return them, that probably is to your benefit. And the best way to analyze it, I saw a comment in the chat box, the best way to analyze these multiple offers is completely objectively based upon the terms, put it on a spreadsheet, and make sure that you've compared all the different terms, not just the price, but earnest money, closing date, possession issues, financing contingencies, inspection contingencies, and set it up like a grid so that the seller has a good, solid understanding of the various offers that are there. Now, one more caveat about that is you don't want to just present the spreadsheet or the grid. You've got to present the offers with that too. Mm-hmm. So I've heard of somebody saying, oh, well, we totally anonymize everything and just present the spreadsheet. No, you can't do that. You got to present the offers. And the spreadsheet is a tool to help the sellers and you analyze those various offers.
Yeah, great point. Great point. Dita had an interesting comment about buyer's agents now leaving gift cards at the house for sellers. Oh my God. So first of all, I mean, my opinion would be that that's like talking to the sellers outside of the transaction, in my opinion. Greg, what are your thoughts on that?
Well, that's a new one on me. We've had, I mean, for a long time, we had ongoing conversations about providing gifts, small promotional items, things like that to clients, potential clients, et cetera. And generally said it's okay as long as it's not for the purposes of a referral. I guess I'd have to look into that and think about that a little. I mean, under that general guideline, it would be okay, but have to kind of look at that and think about that a little further before we would comment on that. Just a little bit on the love letters, if I may.
Yeah.
Just, I had a really good conversation with a Nebraska broker a couple weeks ago, a long conversation about these. I've had several conversations with licensees. You know, in and of itself, it's not illegal. What's illegal is a fair housing violation.
Mhm.
So as the real estate commission, we can't say you can't do it. I mean, one can certainly theoretically think about a love letter that says, I love your house, I'd take real good care of it, you know, and I don't think that would violate any laws. Now, the problem is, as stated, there's the potential for that, you know, there's the potential for many of those maybe unforeseen, but have some sort of fair housing violation. And one of the things we talked about is, and I've said it's not illegal, but I would agree that discouraging it is not a bad idea because there is that potential. One of the things we always say is don't do things that can come back to bite you, and those love letters can come back and bite you. But one of the aspects we talked about in the conversation was, okay, but if I'm the buyer's agent, I have a fiduciary duty to the buyer, and if the love letter gives the buyer a better chance of getting the house, do I have an obligation to present that love letter? You know, or to try to present that love letter. And I think, you know, I think if you establish a policy as to what you're going to do, you know, we certainly have an obligation to present all offers, but I don't think the love letter is part of the offer. It's not part of the contractual obligation. So I guess what I'm saying is they are not illegal per se, but it is certainly okay to say no to them on either side of the transaction, to say, we're not going to do that.
Cool. All right. Good advice. Thank you. I'm getting multiple comments on pre-inspections. I would say that in my mind, that's a very solid business practice. And sellers will often look at me like I'm crazy and suggesting it. Why would I spend another $500 in my mind, you know, when nobody's asking for inspections anyway? And my answer is always, you know, for your liability protection. You're giving away, you know, you're giving the best knowledge that you possibly can about the house so that you avoid problems afterwards, after the transaction closes. So that $500 peace of mind is powerful. Would anyone else like to say anything about pre-inspections?
Well, I've always thought they were a great idea. And I get, you know, in our market, we tend to get resistance from sellers because, oh, I don't want to find out about anything. Well, my response to that is always better to find out about it now and take care of it than have a buyer find out about it through their inspection. And then you are pretty much stuck with this issue. So if you take care of it in advance, you can tell everybody in advance, and you're not preventing or losing any sales because of something that you actually took care of.
Absolutely. Provides you peace of mind later. Money well spent typically. And also the other powerful thing is it can really drive up that pricing, because you'll get more people that are very comfortable in the product that they're getting. So they're potentially willing to pay more if it's, you know, if it's a clean inspection or some of the items have been addressed. So it really can has the potential of raising up their value. All right. Is there any questions that somebody's like, that was a burning question of mine and you didn't get it answered? Put it in the chat now.
You know, with so many offers coming in with waiving all inspections, I mean, going and telling your seller that, hey, you should have it pre-inspected, and then knowing what's wrong with it and having to disclose that stuff and fix it. I mean, if we're working for this, I mean, are we doing a disjustice to our seller, telling them that there's a good chance you're going to have multiple offers with no inspections, but you should still inspect your property?
Well, so anyone who's been in the business for a long time knows that legal action is threatened on a fairly regular basis over wet basements, bad roofs, because insurance companies just inspected it. So I use testimonials and stories to help explain why it may be in their best interest. Because if they get involved in having to hire an attorney, it's going to cost them a lot more than $500. And again, I do think that it really does have the potential of driving up that pricing, because I think you get more bidders when it's been pre-inspected. And I think you get more peace of mind to the people potentially bidding on it. What are your thoughts, Bruce?
So I was just going to say, you know, it's kind of one of these self-fulfilling prophecy kinds of things. Gee, I'm not going to have it inspected. I'm going to get a no inspection offer. And so therefore I'm legally protected from any later lawsuit. Well, that's just not true. And I see Troy he's shaking his head too. I can't tell you the number of times that I've, in the real estate company I work for, that was where I was managing and defending cases where something allegedly wasn't disclosed. So the issue is not whether the buyer had an inspection. The issue is, did the seller properly disclose it? And they're very hard cases to defend against. So I think it's asking for trouble even in a no inspection case. Troy?
Yeah, I'll add on to that. We are seeing a lot of them where buyers are waiving inspections, but they're also saying they'll take the property in as-is condition. And even that doesn't necessarily protect them from any legal liability. If there is an issue that was not disclosed, they are simply liable, and we're already starting to see it.
Yeah,
I'm starting to get phone calls on cases where they've owned the house about 6 to 8 months, and they're finding things now, and they pull back the carpet and they can't believe what's been hiding underneath. And we are certainly going to see a sharp uptick in failure to disclose lawsuits because of this.
What if it was disclosed? You know, I mean, you know, my sellers disclosed that there's been water in the basement. And then, you know, the second part of that, I mean, I've been doing this 17 years, and knock on wood, I've never seen a lawsuit taken because of the expense of them. You know, and I've had people that have talked about, well, we had cellar in the basement, but financially it was, you know, going to be cheaper for us just to handle it rather than going through the whole process of waiting for it to be taken care of.
Yeah, I think a general disclosure of water in the basement doesn't necessarily protect them. It depends on where the water came from and how the water came to be there and how often the water's been there and what efforts have been made either to remediate it or to hide it. It opens the door, and trust me, I have seen plenty of lawsuits that have to do with failure to disclose, expensive or not.
As have I.
And
so, I will tell you that those basement water cases often turn into mold cases too. And if you add the mold count onto it, then you're really, you know, potentially talking about other issues as well. So good for you that in 17 years, you've never seen anything like this. You're doing a great job as an agent. And I will tell you that agents, no matter how good a job they do, can get caught up in one of these things and not even be aware that there was anything done wrong. And there may not have been anything done wrong. It's just the perception. And a lot of plaintiffs' attorneys will work on the basis of a contingency fee. And if they think they've got a reasonable case and you've got insurance, then the insurance is really your target. Is their target, not you. Your insurance is their target.
Right. And somebody asked the question, what needs to be disclosed from the pre-inspection? I would say everything. If you've done a pre-inspection, then you just put it out there.
I agree.
Yeah. Could you touch on appraisal gaps? Ryan, can you be more specific about what you'd like to know about appraisal gaps?
Are there any, well, one of the things that we had come up this past week was appraisal gaps and specific language about appraisal gaps, and it was a VA loan. And whether or not, because the specific language was added into the contract, whether or not that specific language would actually remove the VA escape clause.
Oh, that's a good question.
And we reached out to 2 different attorneys, 2 different VA underwriters and the VA itself, and we've got multiple answers. So I'd like to hear your guys' take.
Wow.
You want more different answers? I guess my thought would be that I think the VA regulations, and I'm not a VA expert, but I think the VA regulations require that appraisal clause, and I would think that any attempt to override it by other language would be in violation of those regulations. I don't know, Greg or Troy?
I tend to agree with you. And I think that requirement comes just on the lending side. And so if it's foregone, then the lender is probably not willing to lend, and then your financing contingency will probably kick in.
Yeah, but VA buyers have the right to pay more for the property if they want, though, if it doesn't appraise.
And then that's where you're going to run into different answers from every different person.
Right. Yeah,
And,
poor Ryan.
The VA's perspective, and if you read the escape clause, it does specifically mention if any other, I don't have it right in front of me, but if any other provisions are subject to any other provisions. So so our take on it, our belief on it is, once you wrote that provision in with the appraisal gap, the escape clause is no longer enforceable because you have put in it's almost like a aha or a oh gotcha moment. Yeah, we said that we would do the appraisal gap to get ourselves in a position, but now we're not going to buy it because we're going to use this VA escape clause.
Wow, it sounds like it's probably going to be debatable to whatever arbitrator or attorney is more talented.
I will say, I had one earlier this year where it was a VA loan and they said they'd make up any difference, and it didn't appraise by a couple thousand, and the buyer made up the difference with cash, and it was literally a non-event with the lender and the underwriter. So it could just vary by the lender and their underwriting team as well.
I would agree.
I don't think you'll find a lender that will close a VA loan without the VA escape clause, regardless of what lawyers or agents say.
Well, they signed the VA escape clause, but because they had language in the contract saying that the VA buyer would make up any difference between the appraisal, I think that overwrote, I guess, the escape clause.
Debbie Mitchell is saying the veteran may purchase at a higher price than appraisal, which I agree with. I've heard of it happening. Yep. It's absolutely allowed. So, but they can only get the loan amount for the appraisal. So, and then I'm seeing another, I'm going to switch gears. We're at the end of our time here. So, and I feel like we could have an all day session on multiple offers. So I'm going to do one last one because I've seen it come up a few times. Can a buyer's agent write multiple offers on multiple homes at the same time, even if they can only close on one? We are seeing that more and more on our marketplace. And what I'm telling my brokerage people is, as long as you reveal that you have multiple offers out and then it's contingent upon the other buyers not accepting first, it's kind of about like turnabout is fair play. You know, I mean, so that's been my advice. Am I about to be told that that is incorrect?
Yeah, my answer is yikes.
Yeah.
And the reason I say that is because remember the risk that a buyer is taking. Can they do it? Sure, they can do it. The risk the buyer is taking is that multiple sellers accept at simultaneous times.
Yeah.
So Troy's shaking his head.
No, I wholeheartedly agree. The last thing you want is for two offers to be accepted and then your buyers are stuck.
Yeah. Even with that contingency clause in there?
I just don't think that it's a very good practice to put multiple offers.
Yeah, it's a tough practice, but would they have, I mean, is it legal in terms of contingent upon?
Well, yeah, but then you can get into the same issue. If the argument is that, yeah, seller A and seller B accepted simultaneously, then the contingency cancels itself out in each contract. Then there's also the comment in the chat box, a buyer can withdraw their offers. No question, they can. But the problem there is timing. Again, I just get very nervous about getting, as a buyer's agent, I get simultaneous calls or texts from 2 listing brokers saying, we've accepted your offer. Wow.
Yeah.
Now, I've never seen it, but it's like, it's too much risk for me to advise a buyer to do that.
So
Yeah.
is it legal? Yes. Should any agent advise their client to do it? No.
Right. I hear you. I hear you. And it really was driven by buyers. Buyers are getting desperate,
Sure.
you know? So, yeah, that has come about. So it is 11:03, and I like to make sure that we stay on task. We have great resources here. Troy Bird from the Nebraska Realtors Association from the Legal Hotline is amazing. And Greg Lemon has always been receptive and very, very helpful. So if you have further questions beyond this, feel free to reach out to those two, and certainly hope that you'll take some of Bruce's classes. Christy tries to employ him often because he's an amazing speaker. So thank you, everyone.
Thank you very much.
Appreciate it.
Thank you. Have a good day.
You too. Bye-bye.